Hi everyone, my name is Daniel Chesmore and we're going to start our next topic for bar review on constitutional law. I'm going to do everything that I can to give you a review of all constitutional law topics from a standard law school curriculum, going from the beginnings of judicial standing to separation of powers, removal, limitations on state regulatory and taxing powers, taxing and spending clause, the 10th Amendment, state powers, federal executive powers. We'll talk about some useful case law, Fourth Amendment challenges, but usually Fourth Amendment will pertain to criminal procedure, which we'll try to cover in later videos. We'll move on after starting from the separation of powers, as well as the 10th Amendment and a little bit on the 5th and 14th Due Process Clause. We'll do more of that in depth when we talk about equal protection and free exercise, and also about free speech. And so this should give you a good synopsis of everything that we need to really ace the bar exam and to pass on our first attempt, whether if it's applying these rules to multiple choice questions in the MBE or for the essay. And we'll try to do this in installments of 1-hour videos so you can take a break in between, and please feel free to leave any comments. I'll do my best to answer them. So we'll start here actually at the very beginning on this concept of judicial review. Now, judicial review, emphatically the province and the duty of judiciary to say what the law is, and this power is derived from Article 3, in which federal courts have subject matter jurisdiction over all cases arising under the Constitution. And within Article 4, the courts have the right to declare constitutional as supreme law of the land. The Supreme Court can declare the supreme law of the land, and all federal laws pursuant to which entails interpretation of the Constitution. And when the courts decide to grant judicial review, they have discretion to act, and federal judges ought not to second-guess the executive branch when president has a duty. Federal courts may enforce duties as well, and we'll talk about the separation of powers later on in this video, but just high-level judicial review, Article 3, federal courts have subject matter jurisdiction over all cases arising under the Constitution. And we'll talk more about other types of cases, and we'll talk about subject matter jurisdiction specifically when we talk about civil procedure in our subsequent videos. And so standing, in order to have a case, we need standing. So standing can be we need all these elements here for injury in fact. We need an actual or concrete or an imminent injury, not necessarily a speculative injury that is neither conjectural or hypothetical. We want some sort of causation. We want a defendant who actually caused the plaintiff's injury. And that causation element is what bridges the injury to our last element with some sort of judicial remedy, in which the courts can provide redress for a disgruntled or an aggrieved plaintiff's injury. And so we can't have any generalized grievance. There is that nexus requirement, as we talked about, within causation for taxpayer standing. And the opportunity to compete or a loss of opportunity to compete might also be an injury, not necessarily a physical injury, but other types of injury in fact, which we can talk about later on, and you might see that in multiple choice. And part of causation, as we explained, is that logical link between the taxpayer status and the type of legislative and the type of actual effect. There's a general prohibition on taxpayer standing, which we'll talk about, and that nexus requirement between status and precise nature of a constitutional infringement alleged is part of that causation. And so we need that logical nexus between that injury as well as the defendant's conduct and any sort of infringement to prove that logical link. Also, we have this concept of justiciability. It's the 11th Amendment, which actually protects state courts from government suits in federal court. There was an exception in the Ex parte Young case where a plaintiff may sue a sovereign state official for equitable order directing a prospective complaint with the law. And also we have this concept of what's called political question here in green. It's a constitutional text that allows us to decide for another branch, requires finality within political questions. We look to the text, and this will actually come about when we talk a little bit more about separation of powers. And so here, we'll actually delve right in. So we started off with judicial review, which gives court to the court's the jurisdiction to hear cases involving any sort of constitutional issue. We'll talk more about federal question when it comes to civil procedure, but just for our knowledge in the constitutional law context, judicial review allows the federal courts to have subject matter jurisdiction over issues of federal question. And when that judicial review is granted, federal judges ought not to second guess the executive branch. Federal judges are really to interpret the law, and depending on your theory of the law, which you can talk about, if you are someone who is more of an originalist, who believes in looking at the four corners of a textual document, as opposed to viewing the Constitution as a living, breathing document, as Justice Ginsburg or as Justice Breyer, for example, that you can talk about on an essay. But always good to argue different perspectives and both sides before reaching your conclusion. And so, separation of powers. Remember here that we have no line item vetoes under the famous Clinton case. So the president must either sign into law an act from Congress passed by both chambers of Congress, since we are a bicameral system, or veto an act in its entirety. Otherwise, this would be an infringement, and that's part of the separation of powers logic, that the executive shouldn't be able to do a line item veto and scratch out a certain area of law which she or he might not agree with. And so that is a first start for us to think about separation of powers, that prohibition of a line item veto in which a president should not be able to strike a specific part of legislation, and they should either approve it in whole or veto it in whole. And so we have the Morrison test here. We've got the functional blending approach, which impedes congressional ability to perform its function under the Morrison test. It's so central that it cannot be shared with the president in terms of a power for the Morrison test when determining whether authority falls along with any of the three branches of government, if it's the judiciary or the legislature or the executive. And so that Morrison test is very useful for us to look at whether or not there's a blending approach, whether two or more branches of government can share that power, or if it's specifically allocated to one. And there's also this other approach, in addition to the Morrison test, the formalist approach. It's a rigid textual approach, just looking at the four corners of the Constitution and interpreting it as such. I like remembering this as more of like the originalist rigid approach. The non-delegation doctrine is also very useful for us, where Congress cannot delegate its legislative authority to administrative agencies. There is no legislative veto. Bicameralism is required, and so we really need it to be sent to both the House and the Senate for any sort of congressional act. There is the presentment clause in which the president can approve. And also we'll talk a little bit more about this in the section above over there, but for now, executive power is delineated under Article 2. We have that through the Jackson-Youngstown case and the concurrence in that famous case. And so here, under that non-delegation doctrine, in which Congress cannot delegate their legislative authority to administrative agencies, they can't delegate it either to the executive power to itself or to its agents. Inferior officers who are appointed under Article 2, Section 2, by the president alone to the courts of law or in the heads of department. So again, they're appointed by president alone to the courts of law or in the heads of department. We'll talk about that in regards to agencies above, but for now that's a really good high-level meaning for us. There is a removal process, which is also very useful. The removal process in which the president has the power, almost without limit, to remove members of the executive branch, but that removal power is limited when the court perceives a need of independence in an executive branch member, such as within a quasi-judicial independent prosecutor, or a need for independence in a commission. Congress may not eliminate all executive removal power. And so that is a removal power, specifically in the executive, so the president can fire at will anyone from the executive branch. But when it comes to the need in which the court might perceive that need to have independence from the executive branch because it might have a quasi-judicial independent prosecutor function, then that's then Congress may not eliminate all the executive removal power. But still, there might be that need for independence in the commission, which might limit that removal power. So look for that in your facts. There's appointment power under Article 2, Section 2 of the Constitution. There's executive privilege within that. Related, actually, before I move on, within the appointment power, we'll talk about the principal officers, in which the president shall appoint with advice and consent of Senate ambassadors, public ministers and counsels, judges of the Supreme Court, and all other officers of the U.S., but Congress may vest the appointment of inferior officers in the president alone, courts of law, and heads of departments. So it really depends on that function. There might be new departments springing up. So look for that in your facts and distinguish between principal officers and inferior officers. Usually the principal officers are textually included within that section of the Constitution under Article 2, Section 2. And so within executive privilege, falls along the lines of this concept that executive privilege is presumptive. We do a balancing analysis, weigh other considerations. We want to show the need to defeat executive privilege or criminal evidence in certain scenarios. Within the executive privilege, also, the president is absolutely immune from civil suits for monetary damages. President has greater powers in foreign policy matters from domestic arena. So we usually trust the president to have greater policy powers when it comes to foreign policy, such as meeting with foreign heads of state, as an example I like to think about. And war powers under the president, where the executive is our commander-in-chief, and the executive, under the war powers, however, that is balanced against the congressional duty for, and the power given to Congress through the Constitution, where Congress has the power to declare war and appropriate funds to fund any military action. But the president cannot unilaterally declare war, even though the president is the commander-in-chief. So balancing between those two is an issue that we see constantly in historical fact patterns, but also within hypotheticals that you might see on an essay or in multiple choice. Within impeachment, the president can be removed from office only upon conviction of treason, bribery, or other high crimes and misdemeanors under Article 1, Section 2. So look for that. Treason, bribery, or other high crimes. Something like a parking ticket can't get a president impeached, but something like thwarting justice just might. And so that's a high level of our separation of powers. We'll talk about it more in depth up in the section above. But I think that is good for now when it comes to that topic. We can get specific into that separation of powers by first looking at the Commerce Clause. The Commerce Clause and its scope was, in my opinion, and actually you can use this case for your essay when we cite Lopez and the three categories within the Commerce Clause of laws. So within the Commerce Clause, Congress has a right to regulate channels of interstate commerce, instrumentalities or people that travel or work in channels of interstate commerce. That might be such as airplanes or airline employees within channels of interstate commerce. That might be airplane routes or highway routes. And third, I love this the third example because it applies to so many cases, including wheat and plants. This is economic or commercial activity or a non-economic activity that is an essential part of a larger economic activity. So in the aggregate, such as the famous wheat cases or other plant-related cases. And so that's right here, written here, the aggregate effect, in which in this third category, we look to that larger economic activity, such as drug trade or any sort of rational review, which we'll talk about the level of scrutiny later on in this video. But here, Congress cannot overstep state police powers. Violent crimes regulation is left to the states. So a lot about the constitutional law and this underlying theme is a balancing test, and that balancing test comes in play throughout many of these concepts. So think about it like a scale where we balance the federal powers against the legislative powers, maybe the federal powers against the judiciary, and each of those different types of possible iterations. And so within the Commerce Clause, in addition to not overstepping the 10th Amendment, the courts will consider various facts that we can talk about in an essay or a multiple choice, congressional findings. So there was this case relating to abuse, in which examples of abuse here within an illegal market for illegal activity. This is part of a comprehensive regulatory scheme and a larger economic activity, but cannot be too attenuated. We really want a logical chain that isn't attenuated to link the regulated activity to interstate commerce. And so that is our first doctrine, the Commerce Clause. It comes up time and time again. It may be an essay. I'm 100% sure we'll at least have a few multiple choice questions on this. It's always on the bar. Next, we'll talk about the Spending Clause. This is we'll look within the Spending Clause, the logical relationship between rational relation to purpose of federal funds regulated. For that logical relationship, it's a 4-part conditional spending analysis from one of our cases. The first part of the Spending Clause is a condition may be stated unambiguously. It must serve the general welfare. There's great deference given because usually this falls along the lines of rational review, which is the lowest level of scrutiny, as long as we've got some sort of rational relation to serve some sort of legitimate purpose. And it's reasonably related to the purpose funds attached. Third and fourth, it may not cause states to violate any sort of constitutional bar. So here, there was one case that met 4 Spending Clause requirements, but it was still unconstitutional if it coerces states into legislation. We can argue some of the healthcare cases. There was a Garcia case. So long as the law falls in the enumerated power, Congress may regulate traditional state functions. We'll talk about field presumption and that related issue later on, but just keep that in mind for now. And under the Spending Clause, actually under the Necessary and Proper Clause, which is another power, Congress may enact all laws necessary to execution of a valid treaty, for example. So a lot of these powers might overlap, and so to justify Congress's authority to legislate, there's a Spending Clause and the Commerce Clause, and usually we think about these together as part of taxing and spending. And so as long as so argue these all kind of together or see if they're distinguished within. And so spending and taxing, we talked about the Spending Clause and that 4-part analysis. A condition may not be stated unambiguously. It must be stated unambiguously. It cannot be stated ambiguously. It must serve the general welfare. It has to be reasonably related to the purpose of the funds attached. And it may not cause states to violate their independent constitutional bars. And so moving on to the related taxing power, tax must have at least incidental regulatory effect. We want to distinguish tax and penalties, where penalties aren't usually allowed and will be struck down, like the mandate in the Affordable Care Act. No commandeering states without making state law. No commandeering states into making state law. And Congress is really supposed to regulate individual conduct and not coerce states to do so. And so regulatory taxes are usually okay in this case. And so that is taxing power. We can talk about really quick the dormant clause, dormant commerce clause, which is kind of like the inverse of the commerce clause. We want to first determine if state law discriminates between in-state and out-of-state commerce. And if that answer is yes, if the law does, then it's per se invalid because it violates privileges and immunities, unless the state has a reason to discriminate against out-of-state commerce through origin. And so any other feasible option might work in that. And so unless the state is an active participant, market participant, it applies only to market in which the state actually participates. And so we must balance the state interests in law against the burdens on interstate commerce. And so states can discriminate at any time. States can discriminate any other through any other market participant, unless the state is a market participant. And so there's that market participant exception, applies only to market in which the state actually participates. There might be healthcare as a growing example, and we might have more jurisprudence on that. But within the state as a market participant, we want to balance the state interests in law against the burden on interstate commerce. States can discriminate just like any other market participant. If remember, that does not apply to downstream markets. And also, out-of-state laws here. Yes, within this context, we have to also look to that burden on interstate commerce. The Dormant Commerce Clause applies to local laws and municipal laws as well. And so limits on federal power, really quickly. Congress may regulate states on the same, it closes private actors on the same basis as it does to these private actors. Also, we want to talk about, within this context, we'll talk a little bit more about this later, but for the Dormant Commerce Clause, that's good high-level information for determining if the state law discriminates between in-state and out-of-state, and determining whether or not there's like some sort of unique threat, any feasible option here. It's all in blue. So you can pause the video and try to look at my notes within any feasible option for your Dormant Commerce Clause analysis. Limits on federal power. Keep that in mind. Congress may regulate states on the same field or the same as if it does private actors, the same basis. Privileges and immunities clause as part of Article 4. Discrimination against out-of-state individuals this discrimination is justified only if government has a substantial reason for doing so, for treating others differently. The challenge law bears a substantial relationship for treating out-of-state actors differently. Recreational activities like hunting or are not entitled to heightened protection of privileges and immunities clause. We want to look if the challenge law bears a substantial relationship for treating out-of-state actors differently, see if less discriminatory measure would have indicated a substantial reason. Preemption we'll look at. Preemption is a federal law expressly preempts state law. If the state law conflicts with the purpose of federal law, we look to that as part of preemption as our elements. And third, Congress has some complete occupation of the field, complete regulatory powers within that field, and there's no room for state regulation. There are two types of preemption. There's field preemption and there's conflict preemption. Within field preemption, if the field is normally defined as the regulation of smallpox vaccines, for example, then analysis conflict, see if the field is still largely left open to states. The question is whether acts-informed consent establish floor or a ceiling within conflict preemption. So field If that field is narrowly defined as to regulation, we want to see whether or not there's room to actually regulate within that field, or conflict. If we look at that question of whether or not Congress, whether or not we've got some sort of establishment of a floor or ceiling, Brady is very useful. State tax on interstate commerce is only valid if one applied to actual to actual jurisdictional nexus with taxing state, is fairly apportioned and does not discriminate against interstate commerce, and is fairly related to services of the state. So that's more useful case law for us. Okay, so fundamental rights generally, we'll talk about this later on in due process. We'll touch upon it, but very generally here for fundamental rights, the government may only regulate a fundamental right if it has a compelling reason. So this is heightened scrutiny. We start with the lowest level of scrutiny, rational relation. So if we've got some sort of general law that applies to economic regulation, that will have the lowest level of scrutiny, rational, if it's rationally related. So rationally related to some sort of legitimate purpose. But then we've got heightened scrutiny, otherwise known as strict scrutiny, applying to some fundamental rights, in which we'll need a compelling reason. And we'll talk about that later on within the context of First Amendment free speech rights. But that compelling reason is needed, but also that compelling purpose, it might have a narrow tailored requirement, and it might be the only means in which to advance that compelling reason. We see that a lot with the COVID-19 pandemic, in which we see complaints from actors, from individuals complaining against state actors for keeping them quarantined or for making them wear a mask. I read a few cases in my spare time, and even if strict scrutiny were to apply, there were a number of cases in which strict scrutiny passed that test. It's usually a very difficult test to pass, but if we have some sort of fact pattern in which the compelling reason is to protect public health, and the only way we can do that is to require people to wear masks or to self-quarantine, then strict scrutiny, if that is what the courts deem to be the applicable level of scrutiny against a fundamental right, then it may very well pass, and it has. There was a federal case in Hawaii relating to the state's quarantine laws, and that actually passed the heightened level of scrutiny. It could pass both the rational relation tests, rational basis review is another word you can use for it, another term you can use for it, or strict scrutiny. So that is strict scrutiny review. That usually applies to fundamental rights. Government may only regulate a fundamental right if it has a compelling reason, and the regulatory means chosen are necessary or narrowly tailored to achieve that government objective or interest. Within strict scrutiny, we'll talk about fundamental rights, but usually for the purposes of the bar exam, we see this in the context of our abortion cases. Abortion is a fundamental right. And we also see that within discrimination cases as well. We'll see that later on. And so there's a high deference there and a high standard to meet. And so that is fundamental rights and undue burden test, which we'll talk about later, and we'll talk about narrow tailoring as related to that requirement. And that is good for now. We talked about a lot of separation of powers and general taxing and spending and the Commerce Clause, and we talked about whether or not the executive, within the executive powers in the context of separation of powers, may unilaterally rescind a treaty. The executive can. No crisis is required to revoke a treaty, such as revoking NAFTA, for example, as President Trump has done. And so President has greater powers when it comes to foreign policy than from the domestic arena, since we really need one head of state to meet with other international heads of state and to negotiate those treaties. We don't really see that often within this context, but just know that there may be a right for the president to unilaterally rescind a treaty, such as the Trans-Pacific Partnership, which is a more recent example. And we talked about removal powers, where if it's within the executive office, then usually the president will have the power to remove executive officers without issue, almost limitless power. but that removal power is limited when the courts perceive a need of independence in some sort of quasi-judicial or quasi-legislative capacity, in which it's good to have impartiality. Non-delegation doctrine, Congress cannot give away their lawmaking function. They can create different agencies, as we talked about, like that quasi-legislative, quasi-executive agency. And then we looked at the Jackson-Youngstown concurrence case. We also looked at the applicable tests. When we talk about separation of powers, we look for express or implied authority where it's most justified. We look whether or not there's some sort of middle ground in which there's a zone of silence, or otherwise known as acquiescence, where Congress has not acted to neither grant or deny executive authority. And separation of powers usually is least justified when it comes to stepping in, overstepping another branch of government, when acting against the express or implied statement of the will of Congress. And so that is our jurisprudence here. A lot of this comes from case law that we've studied in constitutional law. So just remember that when looking at separation of powers, look for any express or implied authority, look for some sort of middle ground or silence where Congress is not added to grant or deny the executive authority, and look for whether or not there's an express or implied statement of the will of Congress, and that can be denoted through a number of facts, as we'll later see. And so next we'll talk about this chart here about removal. We'll talk more in depth on separation of powers, and we'll talk about different tests for fundamental rights. We'll talk about limits on state regulatory and taxing power and the federal executive power. We'll talk more about separation of powers. This is just more of a high-level view of the first part of constitutional law. And our next video will be a little bit more in depth. Before we move on to the First Amendment, free speech rights, time, place, manner restrictions, designated forums, and other sorts of issues related to either the Equal Protection Clause or the Due Process Clause in our next video.